Good evening. I think we're on now. Okay, so good afternoon, good morning, and good evening to all of you who have joined us. I think there are probably about 20 of us, 20 of you, I should say, who have signed in, and we may expect about 10 more, because about 30 of you have registered to listen in today. Thank you very much for that. My name is Natalie Wiseman, and I am a legal advisor at the ICRC in Geneva in the Arms Unit, and I will be presenting to you today on what we might expect between now and the March Diplomatic Conference on the ATT, and what you might be able to do to promote a strong treaty. Before I begin the actual presentation, I thought I'd explain a few practical details. As you might have already noticed, this webinar is meant to be interactive, and you should be able to write questions to my colleagues Catherine and Audrey, who are sitting right next to me, and will be reading your questions and sending them over to me during the question period. And so you can just write them into the little box that's on the bottom right-hand corner of your screen and click send to actually not Catherine's name, but Boualem Belbashir. That is the person to whom you need to send your questions. They will send them to me, and I will try to answer as many as possible during our question period. I will, because it might be interesting for all of you to know who is asking the questions, I will be reading out your name when I read out the question and try to answer them. But if you do not want me to read out your name, please say so, and I will not. You should be able to listen to the webinar through the loudspeakers in your computer, but if you can't, you'll see, I think on probably the next slide, you'll see a phone number that you can call and a code that you'll need to dial that will allow you to listen in by telephone, although the call will not be free of charge. Finally, this webinar is going to be recorded, or is being recorded, so you'll be able to listen to it again, and your colleagues will be able to listen to it as well if they are interested. We'll send you the link once the webinar is over. And one last point, you may have already heard, but we've just launched a new film on the need for an arms trade treaty, and so at the end of this webinar you'll be directed straight to the website where you can watch it if you're interested. And you should also know that all ICRC delegations and national societies should be receiving, or may have already received, copies of the film. So, I'm going to begin the presentation now. Feel free to write questions as they arise. And my colleagues will manage them. All right. So I realize that many of you have followed this process for as long as I have, but perhaps some of you have not, so forgive me for repeating things that you already know, but I hope this will be informative for everyone. So I'll start with the process. As many of you may already know, there was a diplomatic conference, the first diplomatic conference, to negotiate an arms trade treaty in July 2012, so just a few months ago, and the link that you see on this slide should lead you straight to various language versions of the draft treaty that the conference ended with. The conference did not succeed in adopting a treaty, but ended with the first ever draft arms trade treaty that you can see by clicking on that link. Now, luckily, the story didn't end in July, and there will be a new diplomatic conference entitled the Final Diplomatic Conference. The word final is not accidental. The UN General Assembly adopted a resolution at the end of 2012 calling for the final diplomatic conference on the ATT, hoping that once and for all a treaty will be adopted this month in just a few days from March 18th to 28th in New York at UN headquarters. And you should know that the negotiation will begin on the basis of the draft treaty that you can find by clicking on the link on this slide, and that emerged from the July conference. So discussions will be based on this draft treaty at the outset. The procedure that will follow will be the same as in July, and the most important rule of procedure is that of consensus. States will need to, if they adopt, will need to adopt a treaty by consensus, not by vote. However, I mentioned a General Assembly resolution just a few seconds ago that called for this final diplomatic conference, and that General Assembly resolution also basically left a window of opportunity to take the treaty adoption to the General Assembly later this year, should the final diplomatic conference not succeed in adopting the treaty. So that's a little bit of process and background and procedure for you. And now I will move on to what we have done between July and now, and plan to do between now and the diplomatic conference. And what's on this slide is meant to give you a sense of the documents that we've worked on that might help you as tools in your thinking and in your discussions with authorities as we move towards the conference. So first, we've been involved in many meetings all over the world to try and develop thinking about the draft treaty and to try and strengthen it, because as time has passed, more and more flaws have revealed themselves, as you'll hear in a few moments. We also, just a few weeks ago, held a meeting of legal and political experts from about 18 countries and 5 non-governmental organizations to explore some key issues in the draft treaty, and we're just about to issue a report on the meeting for the participants of the meeting. We also just sent last week an analysis of aspects of the draft treaty to Ambassador Peter Wolcott, who will be the Australian ambassador presiding over the conference in just a few weeks, or a couple of weeks, in New York. And we will also be making public a short document setting out our position on some IHL aspects of the draft treaty, and that should be online, but it isn't yet. Also, very soon, you should all be receiving a note with some of our key messages, so sort of a boiled down version of a lot of the documents I've referred to so far. And in March, of course, as usual, we'll be engaging in public communications, press releases, an online interview, and possibly other measures to promote a strong and comprehensive arms trade treaty. So these are some of the documents that you can already think about asking us for if you think that you'd like to look into this further. And sorry, I may have. Now I'll go into substance a bit more and remind you, in case you may have forgotten, what our key objectives are and have been for a very long time in promoting a strong arms trade treaty. And the first bullet point refers to a broad scope. You'll be hearing me use the word scope a lot in this webinar. And by scope, we refer to the kinds of transfers that the arms trade treaty will be covering, and the kinds of weapons and ammunition that the treaty will be covering. And I'll go into that in just a few minutes or seconds. And the other big objective that the ICRC has had so far in promoting a strong arms trade treaty has to do with transfer criteria, so the standards by which states must authorize transfers of conventional arms. And the ones that we have been most interested in are transfer criteria based on IHL and international human rights law. And so I'm going to address those main objectives by referring to the draft ATT so that you can see what the draft ATT says and how it relates to our objectives, and perhaps see some of the good and the bad for yourselves. And so I'll start with, I believe I'm starting with scope, and that can be found in Article 2 of the draft treaty, and then I'll move on to prohibitions and transfer criteria that are covered in Articles 3 and 4. Yes, I am starting with scope. So this on the slide is just an excerpt of the draft treaty to show you what it says on what scope of weapons the treaty will apply to. And so it says, as you see, the treaty shall apply to all conventional arms within the following categories at a minimum, and then it lists 7 categories of weapons plus small arms and light weapons. And those categories of weapons, the 7 before small arms and light weapons, come from the UN Register of Conventional Arms. That is not an exhaustive register of all conventional arms that are out there. And so the main point that we have to make here is that while the scope of weapons in this provision is rather broad, particularly because it includes small arms and light weapons, it is not comprehensive, it is not exhaustive. Even though it says at a minimum, it still says shall apply to all conventional arms within the following categories, which means that the compulsory scope is these categories, but of course countries would be free to add other weapons to their control list if they wish to do so. And I should add that Safer World has done some very thorough research that has revealed that countries responsible for 98% of arms exports already regulate the export of a much broader range of weapons than these 8 categories covered in Article 2A. Now, the good news is that we don't just have Article 2A, because Articles 6.4 and 6.5 also say that each state party shall also regulate the export of ammunition and parts and components for the weapons that we just looked at on the previous slide. And that's obviously very important because ammunition is the fuel for many weapons that are already in circulation. And if we're concerned about how those weapons will be used, then we certainly ought to be concerned about whether ammunition is provided to fuel those weapons or not. And parts and components are important because most, or maybe not most, but many weapons are actually transferred by their parts and components, and many weapons need new components and new parts. And so the regulation system would only be complete if all the parts that fuel the weapons themselves are regulated as well. Now, that's the good. The potentially bad is that, as you may have noticed, the rule on ammunition and parts and components is not in the slide that you have before you on the regulation of exports of ammunition and parts and components is not covered in Article 2, which is on this slide, but rather in a separate section of the treaty, Articles 6.4 and 6.5. And the implication of that is that any time that the draft treaty refers to the scope of weapons, it may be that ammunition and parts and components are not considered to be within the scope of the treaty or the scope of weapons. And that can have implications if you look throughout the draft treaty. Any reference to the scope of weapons under the treaty would not include ammunition or parts and components. I'll leave it at that, but you're free to ask me more questions on that. But like I said, it's already very good that the draft treaty contains a provision on ammunition and parts and components, although I should say that it's not because it's in the draft treaty that it will necessarily survive or survive where it is. A lot of the issues that I'm going to address today are still very much in dispute. Moving on to the scope of transactions now. Ideally, and this is the ICRC position, the treaty should cover all types of transactions that involve the movement of weapons from one state to another recipient. Should the treaty not cover all such movement or transfers, you could well imagine the significance of the loopholes that would bring. And so the draft treaty right now says this treaty shall apply to those activities of the international trade in conventional arms, and then refers to Articles 6, 7, 8, and 9, which deal with export, import, brokering, transit, and transshipment. And all that looks pretty comprehensive, except, and you'll see I've underlined the word trade, except that the word trade, we know for some states, will need to be interpreted in a restrictive manner to mean only commercial transactions that involve essentially buying or selling weapons. And so if that's the narrow interpretation that is given to the word trade, then you could well imagine that gifts and loans of weapons would go unregulated and be carried out to circumvent the ATT. On the other hand, there is a strong and rather large group of countries that insists that there is no need to restrictively interpret the word trade, and that it should involve all sorts of transactions, including gifts and loans. So it's an issue that's very much in debate. I think to make it extra clear, it might be better to replace the word trade with transfer, but we also know quite well why the word trade is there, and it is because some states want to restrict the scope to only commercial transactions. I'm going to move on now because there's still a lot to cover, and I want to allow you to send as many questions as you like and try to answer them all if I can. So I'm going to move on from scope now to the more direct, the more IHL-related provisions in the draft treaty. And I'll start with the prohibition that you'll find under Article 3.3 of the draft treaty, and I've got an excerpt there for you, and I'll read it out anyway. A state party shall not authorize a transfer of conventional arms for the purpose of facilitating the commission of genocide, crimes against humanity, or war crimes constituting grave breaches of the Geneva Conventions or serious violations of Common Article 3 of the Geneva Conventions. Now, the lawyers out there are, I hope, already noticing the flaws in this wording. I'm going to go into some of them, not all of them, because we don't have time, but the two most important flaws that we're trying very, very hard to fix, and that I would urge you to try very, very hard to fix with your interlocutors are underlined, and they have to do with the words "for the purpose" and the scope of war crimes that are covered in the provision. And on "for the purpose," actually I'll go back to the last slide and point out the flaw here. If you think about it, this provision is asking a state to refuse a transfer if the transfer is intended to facilitate war crimes or genocide or crimes against humanity. And that means that a state party would have to ask itself if it intends to help facilitate the commission of these crimes. And it is very difficult to conceive of any state that would ask itself whether it intends to facilitate these crimes and answer yes to that question. And so it would seem to be an inoperable provision because no state will answer yes, especially if it means that if it intends to facilitate the crimes, it therefore cannot transfer them. And now I'll move on to the next slide to point out something else, and it's that for the purpose, which, as I just mentioned, entails a specific intention to facilitate these crimes, is not consistent with the rules on, or draft rules on state responsibility, and in particular Article 16, which says that a state is responsible for aiding or assisting another state in an internationally wrongful act if that aiding or assisting state does so with knowledge of the circumstances, and the act would be wrongful if the transferring, let's say the arms transferring state committed it as well. And so I've underlined the word knowledge there because knowledge is the accepted standard under Article 16 for state responsibility. While some countries read in intent, others don't read intent into the standard of knowledge. And so our proposal is that instead of using the term for the purpose, there be a reference to Article 16 language and the standard in Article 16 for a state's responsibility for aiding or assisting in the violation of international law by another country. And so on this slide are two of, I'm sure we could all think of many other proposals to reflect Article 16 and the standard of responsibility in Article 16, but these are just two proposals that we have been encouraging countries to consider to fix that part of Article 3.3, and both, as you see, take words, basically reproduce the words used in Article 16. So one is if the transfer aids or assists in the commission of the crimes listed in Article 3.3, or if the state party knows that the arms will be used to facilitate the commission of the crimes in Article 3.3. And that also gets us away from the inoperability of having a state have to ask itself if it intends to facilitate certain crimes. So that's on for the purpose. And now the other flaw that I think hopefully many of you have already picked up is the fact that that Article 3.3 only refers to war crimes set out in the Geneva Conventions. And as I'm sure many of you know, there are many, many, many more war crimes than those set out in the Geneva Conventions. And what's most flagrantly missing is the type of war crime that is carried out in violations of rules of IHL on the conduct of hostilities. The conduct of hostilities rules aren't in the Geneva Conventions. They're in the additional protocol, first additional protocol. They're also set up in the Rome Statute on the International Criminal Court that's been adopted by that is more than adopted, that has been ratified by 122 countries and signed by even more. And so some of the war crimes that are not included in Article 3.3 are here on this slide, and they have to do with direct attacks, intentional direct attacks against civilians, civilian objects, personnel, installations, etc., involved in a humanitarian assistance mission, hospitals, buildings dedicated to religion, etc., etc. You can read it for yourselves, I'm sure. And I think many of you will acknowledge that these are also the kinds of war crimes that we would hope to prevent by not authorizing arms transfers when there is a concern about war crimes. These are the war crimes that are most commonly carried out, or maybe not most commonly carried, but so commonly carried out that we ought to be concerned about these as well, and they are missing. So another proposal to make to fix or improve Article 3.3, well, there are a few proposals here on this slide, and they go from something as simple as just referring to war crimes instead of war crimes constituting grave breaches and serious violations of Article 3, or war crimes including grave breaches and serious violations of Common Article 3, or grave breaches of the Geneva Conventions, or serious violations of the laws or customs of war. And that term, violations of the laws or customs of war, is taken from the statute of the International Criminal Tribunal for the former Yugoslavia. It's also language that is in the Rome Statute of the International Criminal Court. I mean, they're slightly different, but the notion of laws or customs of war and violations of laws or customs of war is found in both those criminal court statutes. And in fact, in both those statutes, there is a distinction made between the grave breaches of the Geneva Conventions and other types of war crimes of the kinds that I listed on the previous slide, entailing violations of IHL rules on the conduct of hostilities. And the final proposal, although there are many more that we could think of here too, says war crimes that violate its obligations under international law. And this one could be perhaps more of interest for countries that have not, for example, not recognized the customary nature of the ICC statute war crimes, but recognize a narrower range of war crimes, and so wouldn't want to simply refer to war crimes if they don't recognize the same range as 122 other countries. And so war crimes that violate its obligations under international law could perhaps comfort a country by letting it, understand that it would only need to be concerned about war crimes that it already recognizes. I hope that's made sense. Moving on to now a tricky provision, but that goes to the core of the ICRC message for the last 5 years, and I've been in this job for 5 years, and it has to do with criteria, with transfer criteria. It's in Article 4, which is entitled National Assessment, but they are, it sets out transfer criteria, and I've just listed some of the provisions. I've missed one, but these are the key parts of the provision. The first paragraph of Article 4 asks a potentially transferring state to consider the benefits to and the risks to peace and security of the weapons being transferred. Article 4.2 asks a state party to carry out an assessment of the risk of violations of IHL, of human rights, and acts of terrorism with the weapons being transferred. Article 4.3 refers to applying these rules in an objective and non-discriminatory manner. 4.4, interestingly, allows a transferring state to consider taking risk mitigation measures in order to be able to carry out a transfer of weapons. And as you'll see, 4.5, which I'm going to get into in a lot more detail in just a couple of seconds, says that a state shall not authorize a transfer of weapons if there is an overriding risk of serious violations of IHL or human rights or acts of terrorism. And the word overriding, you'll see, is potentially problematic. And Article 4.6 contains other criteria other than IHL, human rights, or relating to acts of terrorism. It refers to considerations on the impact on development, on corruption, on diversion, gender-based violence, and other factors. And I won't go into those too much, although you're free to ask questions during the question period. I'm going to focus on Articles 4.2 and 4.5. I mentioned 4.2, there isn't that much to say because it speaks for itself. It says that prior to authorization, the state party shall assess whether the export of conventional arms could be used to commit or facilitate a serious violation of IHL or of human rights, and I've cut out, but it's there in 4.2. There's a reference to the risk of acts of terrorism. And I should say that this is a very, very positive development in the draft treaty. The ICRC for years has been calling for a two-step IHL criterion that first requires an assessment of the risk of violations of IHL and then requires a denial of transfer if there is a clear risk of serious violations of IHL. And so that first step is definitely met in Article 4.2. What might not be met is that second step, and I've reproduced the provision here. Article 4.5 says that if after conducting the assessment called for in paragraph 1 and 2, so 1 has to do with the impact on peace and security, good or bad. Paragraph 2 is the one I just showed you on assessing the risk of violations of IHL or human rights. And after considering the mitigation measures that I also just mentioned, the state party, so if after carrying out all these assessments, the state party finds that there's an overriding risk of serious violations of IHL, human rights, or acts of terrorism, the state party shall not authorize the export. And so the idea, the general idea is obviously very positive and sounds a lot like what we've been calling for, which is do not transfer if there's a clear risk of serious violations of IHL. You have shall not authorize language here in Article 4.5. It looks pretty good, except that the word overriding has caused many states to be concerned because we know that some states intend to apply the word overriding to entail a balancing act between the considerations, say in paragraph 1 on the contribution to peace and security of the weapons, against the risk of serious violations of IHL, human rights, or acts of terrorism. And so it's this weighing exercise that could be potentially very dangerous if it means that despite a clear risk of IHL or human rights, a clear risk of serious violations of IHL or human rights, there could still be a transfer of weapons. And so for greater clarity, I seem to have lost a slide in here somewhere. Yeah. Anyway, sorry about that. But anyway, I won't move on to the next one just yet. But for greater clarity, we would recommend replacing the word overriding with clear or substantial, so that there is no such danger of having a state interpret Article 4.5 as allowing it to transfer weapons despite the existence of a clear risk of serious violations of IHL or human rights. I hope that was clear. Okay. Now I will move on to the next slide. So we're moving on from substance. I hope it was clear enough. There's plenty more to say on the draft treaty, and as I mentioned, we've done everything from hold an expert meeting to discuss it over 2 days, to sending Ambassador Wolcott, who's presiding over the conference, an analysis of many aspects of the draft treaty. So I'm happy to share some of that with you if you're interested. But I'll move on to what you can do now and what your role can be. And some of it will be very familiar because it's what we asked you to do before the July conference, and not that much has changed except that we have a draft treaty, but nothing's been adopted yet. And so what you can do is promote the ICRC position with a focus, of course, on the human cost of poorly regulated conventional arms transfers. And also intervene with your national authorities to encourage their active participation, of course, but also to support a treaty that contains strict transfer criteria. So, ideally without the word overriding, but instead the word substantial, so that it's clear that weapons transfers would be prohibited where there's a clear risk of serious violations of IHL or human rights. And also encourage support for a treaty that covers all transfers of all conventional arms and their ammunition and parts and components, because it is obvious that if you don't cover them all, the loopholes can have severe consequences. And of course, at this stage, because we're just days away from the diplomatic conference, the final diplomatic conference, interventions with senior political level contacts would be best. And of course, because we've been so closely involved with many delegations, country delegations dealing with the ATT, I don't mean ICRC delegations, but I mean state delegations, we probably have a lot of names and contact details for you should you need them. And finally, to help your interlocutors, we've got some tools to offer. We have, as I mentioned at the beginning, a brand new film that we launched less than 2 weeks ago, that just went online about an hour or two before you signed into this webinar, on the need to regulate conventional arms transfers and the ICRC's key messages. We also have an ICRC leaflet that we published before the July conference that sets out the ICRC position and lists steps that you can take to promote a strong ATT. And on a more technical question, we have the ICRC's practical guide on how to apply IHL criteria in arms transfer decisions, and it covers everything from what is a serious violation of IHL to what are some indicators of risk of serious violations of IHL. And that was actually published long before we even had an ATT negotiation track to help national authorities carry out arms transfer decisions. And so it's been relevant for a long time. It continues to be relevant, and hopefully, with or without an ATT, will continue to be relevant. So I'll stop here. I hope it was clear and didn't go too quickly. And now